Stop everything you're doing right now and pay attention. On January 9th, 2026, the Department of Homeland Security and the State Department jointly announced a landmark policy change that will fundamentally reshape employment-based green card processing, eliminating country-specific backlogs for EB2 and EB3 categories, and creating a first-in, first-out queue, regardless of country of birth. If you stuck in the decades-long EB2 or EB3 backlog for India or China, if you've been waiting 15 years or more for your priority date to become current, or if you're an employment-based immigrant who thought you'd never see your green card in your lifetime, what I'm about to tell you could move your timeline forward by a decade or more and fundamentally change your family's future in America. This isn't a proposal. This isn't speculation. This is a finalized policy that takes effect on March 1st, 2026, and it represents the most significant reform to employment-based immigration in over 30 years. Stay with me for the next 30 minutes, because I'm going to break down exactly what this policy change does, how it eliminates the per-country caps that have destroyed lives for decades, who benefits most, and who might see slower processing. What you need to do immediately, if you have a pending EB2 or EB3 case, and the 3 critical steps you must take in the next 60 days to maximize this unprecedented opportunity. Let me start with the background, because understanding how we got here and why the old system was so devastating is essential to grasping why this change is so monumental. The United States has annual numerical limits on employment-based immigrant visas. There are approximately 140,000 total employment-based green cards available each year, divided into 5 preference categories. EB1 is for individuals with extraordinary ability, outstanding professors and researchers, and multinational executives. EB2 is for individuals with advanced degrees or exceptional ability. EB3 is for professionals with bachelor's degrees, skilled workers, and other workers. EB4 is for special immigrants like religious workers, and EB5 is for immigrant investors. The problem has never been the total number of employment-based green cards. 140,000 per year is inadequate given demand, but that's a separate issue. The catastrophic problem has been the per-country caps. Under the Immigration and Nationality Act, as it's existed since 1965, no single country can receive more than 7% of the total immigrant visas in any preference category. That 7% cap sounds reasonable in theory. It's supposed to ensure diversity and prevent any one country from dominating immigration. But in practice, it has created unconscionable backlogs for high-demand countries, particularly India and China, where large numbers of highly skilled workers are seeking employment-based green cards. Here's how the math works out. 7% of the approximately 40,000 EB2 green cards available annually is about 2,800 green cards for any single country. If you're from a country with low demand like Norway or Brazil, those 2,800 slots are more than enough, and EB2 is typically current or near current for you. But if you're from India, where there are hundreds of thousands of people in the EB2 queue, 2,800 visas per year is nowhere near sufficient to clear the backlog. The result is that Indian nationals in EB2 have been facing wait times of 50 to 80 years based on current processing rates. 50 to 80 years. That's not a typo. If you're an Indian software engineer who filed for an EB2 green card in 2015 at age 30, you could be 90 years old before your priority date becomes current under the old system. China faces similar but slightly less severe backlogs, typically 20 to 30-year waits for EB2 and EB3. The Philippines and Mexico have also faced backlogs, though not as extreme as India and China. Meanwhile, applicants from the rest of the world, Europe, Africa, South America, most of Asia, have had EB2 and EB3 categories that are current or have minimal waits, because demand from those countries doesn't exceed the available visas. This system has been morally indefensible and economically irrational. You have two software engineers with identical skills, identical jobs, identical contributions to the American economy. One was born in India, the other was born in Canada. The Canadian gets a green card in 2 years. The Indian waits 60 years. How is that fair? How does that serve America's interests? It doesn't. It's an arbitrary punishment based solely on country of birth, and it's destroyed countless lives and families. Now, here's what the January 9th announcement changes and why this is genuinely historic. The new policy, implemented through joint regulations by DHS and the State Department under their existing statutory authority, eliminates the per-country caps for EB2 and EB3 categories. Starting March 1st, 2026, all EB2 and EB3 applications will be processed in a single worldwide queue based solely on priority date, regardless of the applicant's country of birth. If your I-140 was approved on June 1st, 2015, you'll be in line behind everyone whose I-140 was approved before June 1st, 2015, and ahead of everyone whose I-140 was approved after, regardless of whether you're from India, China, or anywhere else. This creates a truly first-in, first-out system, where your place in line is determined by when you applied, not by where you were born. It's what the employment-based system should have been from the beginning, and it's what advocates have been fighting for decades. The practical impact is that hundreds of thousands of Indian and Chinese nationals who've been stuck in impossible backlogs will see their priority dates become current years or even decades sooner than they would have under the old system. And yes, applicants from rest-of-world countries will see slightly longer waits than they had before because they're now competing in the same queue as everyone else, rather than having a separate, faster queue. But the overall effect is dramatically more fair and more efficient. Let me give you a concrete example of what this means. Rajesh is an Indian software engineer who's been working in the United States on an H-1B visa since 2012. His employer sponsored him for a green card in the EB2 category, and his I-140 was approved with a priority date of March 1st, 2014. Under the old system with per-country caps, Rajesh was looking at a wait of approximately 50 to 60 years from his priority date. He's currently 42 years old, which means he'd be in his 90s or dead before getting his green card. He's been living in legal limbo on H-1B for 14 years, unable to change jobs easily because of the green card sponsorship, unable to start his own business, unable to plan for his future with any certainty. His kids, who were born in the United States, are U.S. citizens, but Rajesh and his wife have been stuck in temporary status with no path to permanence. Under the new policy taking effect in March, Rajesh's priority date of March 2014 puts him near the front of the new worldwide queue. Based on preliminary estimates from immigration attorneys analyzing the data, priority dates in the new worldwide EB2 queue should be current up to approximately late 2015 to early 2016 within the first year of the new system. That means Rajesh, with a March 2014 priority date, could potentially have his priority date become current in 2026 or 2027. Instead of waiting until he's 90, he could get his green card in his mid-40s. That's a 40 to 50-year reduction in his wait time. This is life-changing. Now, before everyone gets too excited, I need to explain the mechanics of how this will actually work and why the transition period is going to be complicated. The State Department's January 9th announcement includes detailed implementation guidance that's critical to understand. Starting March 1st, 2026, The Visa Bulletin will no longer publish separate cutoff dates for India, China, Mexico, Philippines, and rest of world in EB2 and EB3 categories. Instead, there will be a single worldwide cutoff date for each category. We just covered how the new policy creates a single worldwide cutoff date starting March 1st, and now we need to talk about how USCIS and the State Department will determine that cutoff date, what the initial March bulletin will look like, and what complications you need to watch out for during the transition. Let me walk you through the mechanics of how the new queue will be ordered, because understanding this helps you estimate where you'll fall in line. As of December 31st, 2025, USCIS and the State Department have compiled a comprehensive database of all pending employment-based I-140 immigrant petitions across all service centers and all countries. This database includes approximately 850,000 approved I-140 petitions in EB2 and EB3 combined that are waiting for visa numbers to become available. The agencies have sorted this entire database by priority date, creating a single worldwide list running from the oldest priority dates in the early 2000s through the most recent filings in late 2025. This started list becomes the new queue. The State Department will allocate the available EB2 and EB3 visa numbers each month to applicants in priority date order from this queue, regardless of country. In practical terms, this means that in the March 2026 Visa Bulletin, we'll see a single EB2 worldwide cutoff date and a single EB3 worldwide cutoff date that reflect how far down the sorted queue the State Department can reach, given the available visa numbers for that month. Based on leaked preliminary data from State Department officials speaking to immigration attorneys, the initial March 2026 Visa Bulletin is expected to show an EB2 worldwide cutoff date of approximately December 2014 to March 2015, and an EB3 worldwide cutoff date of approximately June 2014 to September 2014. Let me explain what this means for different groups of people. If you're an Indian or Chinese EB2 applicant with a priority date before December 2014, you're about to become current after potentially waiting over a decade. If you're an Indian or Chinese EB3 applicant with a priority date before June 2014, same thing. You're about to see dramatic forward movement. But if you're a rest of world EB2 applicant with a priority date of, say, January 2020, you're going to face a wait you didn't expect. Under the old system, EB2 for rest of world was current or near current, meaning January 2020 priority dates could file for green cards almost immediately. Under the new system, you're behind hundreds of thousands of Indian and Chinese applicants with earlier priority dates, which means you're looking at a wait of potentially 3 to 6 years before your priority date becomes current. This is the trade-off inherent in the new system. It's more fair overall, but it does create longer waits for countries that previously had faster lanes. This is general information, not legal advice, but immigration attorneys are advising rest of world EB2 and EB3 clients to understand this change and plan accordingly. If you're from a country other than India, China, Mexico, or Philippines, and you are counting on quick EB2 or EB3 processing, you need to recalibrate your expectations. You're not being discriminated against. You're simply being put in the same queue as everyone else, but your timeline just got longer. Some attorneys are advising certain rest of world clients to consider whether they might qualify for EB1, which is not subject to the same queue and still has per-country allocations that favor rest of world applicants. If you have credentials that could support an EB1 Extraordinary Ability Petition, or if your employer could file an EB1 Multinational Executive Petition, that might now be a faster path than EB2 or EB3. Now, let's talk about a critical detail that's causing confusion: the difference between having an approved I-140 and being able to file for adjustment of status or proceed with consular processing. Having your priority date become current under the new visa bulletin means visa numbers are available, and you can move to the next stage, filing I-485 if you're in the United States, or scheduling your immigrant visa interview if you're processing abroad. But you can only do that if your I-140 petition has already been approved. If your I-140 is still pending at USCIS, you cannot proceed even if your priority date would be current, because you need that I-140 approval first. This is creating a bottleneck that's dampening what should be universal celebration about this policy change. Remember earlier when I mentioned that USCIS restructured into USIBA and USIVES with stricter adjudication standards? Those stricter standards are causing I-140 denial rates to increase, and processing times for I-140 petitions have also increased significantly. As of early January 2026, I-140 processing times are running 12 to 18 months at most service centers, and some complex cases are taking even longer. So if you filed your I-140 recently, you're looking at a year or more before it's approved, and only after approval will your priority date matter for visa availability purposes. Let me give you another scenario that illustrates the complexity. Wei is from China. She's been working in the United States on an H-1B since 2016. Her employer filed an I-140 for her in EB2 category in 2017, and it was approved with a priority date of May 1, 2017. Under the old system, with per-country caps, Wei was facing a wait of 20 to 25 years. Under the new system, her May 2017 priority date puts her a couple of years behind the initial March 2026 cutoff dates, which means she'll probably need to wait another 2 to 3 years for her priority date to become current, as the cutoff dates advance monthly. That's still a dramatic improvement. She'll get her green card in her late 30s instead of her 60s, but it's not immediate. Wei's bigger problem is that she's been on H-1B status for 9 years, which is past the normal 6-year limit. She's been able to extend her H-1B beyond 6 years because she has an approved I-140, which allows H-1B extensions in 1-year increments indefinitely while waiting for a visa number. But each extension costs time and money, and Wei is exhausted from the constant renewals and the uncertainty. The new policy gives her hope that her wait is finite and measurable, 2 to 3 more years rather than 25. But she still has to navigate those years in temporary status. Now let's address the question of retroactivity and whether pending I-485 applications are affected. If you already filed an I-485 adjustment of status application under the old system because your priority date was current under the old per-country allocations, your application remains valid and continues to be processed. The new policy doesn't invalidate existing adjustment applications. However, if your I-485 is still pending when the new system takes effect in March, USCIS will reevaluate whether your priority date is still current under the new worldwide queue. For most India and China applicants who filed I-485, this won't be an issue because their priority dates were so old that they'll remain current under the new system. But for some rest-of-world applicants, it's theoretically possible that a priority date that was current under the old system might retrogress under the new system, though USCIS has stated that pending I-485 applications will not be denied solely due to retrogression. They'll just be held pending until priority dates advance again. Let me talk about the political and legal context of this policy change, because understanding how and why this happened now helps you evaluate whether it's likely to be permanent or whether it could be reversed. The elimination of per-country caps for employment-based green cards has been advocated by tech companies, business groups, and immigrant rights organizations for decades. Legislation to eliminate the caps has been introduced in Congress multiple times, most notably the Fairness for High-Skilled Immigrants Act, which passed the House in 2019 and 2020. But stalled in the Senate due to objections from some senators who wanted broader immigration reforms tied to any change in the per-country system. The Trump administration's decision to implement this change through executive regulatory action rather than waiting for Congress is partly strategic and partly practical. Strategically, it allows the administration to claim credit for a hugely popular reform within the immigrant and business communities, which helps counter the narrative that Trump is anti-immigrant across the board. The administration can point to this and say, look, we're pro-legal immigration. We're helping skilled workers. We're making the system more fair and merit-based. Practically, implementing through regulation allows the change to happen much faster than legislation would. And it's within the executive branch's existing statutory authority to determine how to allocate visa numbers within the constraints Congress has set. But here's the critical legal question. Does the executive branch actually have the authority to eliminate per-country caps through regulation, or does that require congressional action? The per-country cap is established in Section 202 of the Immigration and Nationality Act, which states that no country can receive more than 7% of visa numbers in a preference category. The January 9th regulations don't explicitly eliminate Section 202. They claim to be implementing it in a way that achieves its diversity goals while also promoting efficiency and fairness. The regulations argue that by creating a worldwide queue that processes applicants without regard to country of birth, they're actually fulfilling Section 202's intent to prevent discrimination while recognizing that decades-long backlogs for certain countries undermine the entire employment-based system. This legal theory is clever, but it's untested, and it's virtually certain to be challenged in court. In fact, as of mid-January 2026, at least one lawsuit has already been filed by a coalition of immigration restrictionist organizations challenging the regulations as exceeding executive authority and violating Section 202's clear mandate of per-country limits. The lawsuit was filed in federal district court in Texas, a jurisdiction that's been friendly to challenges against Biden-era immigration policies and that could potentially be hostile to this Trump-era reform as well, if the judge views it as circumventing congressional intent. Immigration attorneys are divided on how the litigation will play out. Some believe the regulations are on solid legal ground because the executive branch has broad discretion in administering visa allocation within statutory limits, and the new system doesn't technically violate Section 202, it just interprets it more flexibly. Others believe courts will strike down the regulations as an impermissible end run around a clear congressional mandate of per-country diversity. If the regulations are struck down, we could revert to the old per-country system, which would be devastating for everyone who's been counting on the new policy. We just covered the legal challenges threatening to overturn this policy change, and now we need to talk about what you must do immediately to protect yourself, how to maximize this opportunity, and what realistic timelines look like for different priority date ranges. Let me start with the most urgent strategic question. If your priority date is about to become current under the new system, what should you do right now to prepare? The window between the March visa bulletin announcement and when you can actually file your I-485 or proceed with consular processing is extremely narrow, and you need to be ready to act immediately. Here's why this matters so much. When a visa bulletin shows major forward movement, which the March bulletin will for India and China EB2 and EB3, there's always a risk of retrogression in subsequent months if demand exceeds expectations. We saw this happen with the January 2026 family-based bulletin that I covered in a previous video. Dates moved forward dramatically, triggering a flood of applications, and then had to retrogress in later bulletins to control the flow. The same thing could happen here. The State Department is projecting that the March worldwide EB2 cutoff will be around December 2014 to March 2015. If everyone with priority dates in that range immediately files I-485 applications, and if the volume exceeds what USCIS anticipated, the April or May bulletin could show retrogression where the cutoff date moves backward. If that happens after you've already filed, you're protected. Your application remains valid and continues processing. But if retrogression happens before you file, you miss your window potentially for months or years until dates move forward again. This creates enormous urgency for anyone whose priority date is likely to be current in March. You need to prepare your adjustment of status application or your consular processing documents now in January and February, so that the moment the March visa bulletin is published in mid-February and shows you're current, you can file within days. Do not wait to see if dates move even further forward in April. Do not delay because you're missing a document or because you want to save money. If you're current in March, file in March, because you cannot count on remaining current in April. Now let's talk about the 3 critical steps you must take immediately. Step 1. Verify your exact priority date and confirm it's correctly recorded in USCIS systems. Get your I-140 approval notice, look at the priority date listed, and make absolutely certain that USCIS has the right date in their database. If there's any discrepancy, if your receipt notice shows one date but your approval notice shows a different date, or if you've had multiple I-140 petitions filed by different employers, you need to resolve this immediately. Contact USCIS, submit inquiries. Get definitive confirmation of what priority date is in their system, because that's the date that will determine when you can file under the new worldwide queue. If you discover there's an error in your priority date, you may be able to correct it, but it requires documentation and time. If you had an earlier I-140 that was approved, but then your employer withdrew it when you left that job, you may be able to recapture that earlier priority date through your new employer's I-140. But you need legal assistance to do this correctly. An immigration attorney can help you navigate priority date recapture, corrections, or porting, which can make the difference between being current in March versus waiting several more years. Step 2. Prepare your adjustment of status package or your consular processing documents immediately, right now, even if you don't know exactly when your priority date will become current. If your priority date is anywhere from 2012 to 2018 for EB2 or 2012 to 2016 for EB3, you should assume there's a realistic possibility you'll become current in 2026. And you need to be ready. For adjustment of status, this means gathering every required document: your I-140 approval notice, your passport, your I-94 arrival departure records, your current visa documentation, your employment verification letters, your birth certificate, police clearances from any country where you've lived for 6 months or more since age 16, your medical examination completed by a USCIS-approved civil surgeon, passport photos, and all forms completed and signed. Schedule your medical exam now. Civil surgeons are going to be completely overwhelmed in February and March, as hundreds of thousands of people whose priority dates are becoming current try to get exams. If you wait until after the March visa bulletin is published, you might not be able to get an appointment for weeks or months. Get your exam done in January or February, get the sealed results, and have them ready. The I-688 medical exam is valid for 2 years from the date it's signed, so even if your priority date doesn't become current until later than you expected, the exam will still be valid. For consular processing, contact the U.S. Embassy or consulate in your home country and understand their specific procedures and document requirements. Different embassies have different processing times and different documentary requirements. Make sure you have all your civil documents, birth certificates, marriage certificates, divorce decrees if applicable, police clearances, properly translated and ready to submit when NVC requests them. Step 3. If you're currently on H-1B or another temporary status, make absolutely certain your status is current and won't expire before you can file adjustment of status. If your H-1B is expiring in the next 6 months, file your extension petition immediately, even if you're expecting to file for adjustment soon. You need to maintain valid status continuously until you file I-485, because if you fall out of status before filing adjustment, you could become ineligible to adjust. Once you file I-485, you can remain in the United States in a period of authorized stay even if your H-1B expires. But you need to be in valid status at the moment you file. If you're abroad and planning to process through a U.S. consulate, make sure you're maintaining lawful status in whatever country you're in. Don't let your visa or residency status in your current country lapse while you're waiting for your U.S. immigrant visa processing, because you need to be legally present somewhere throughout the process. Now let me address the elephant in the room. What happens if the legal challenges succeed and courts strike down this policy change? This is the nightmare scenario that everyone with India or China priority dates is trying not to think about. But we need to confront it realistically. If a federal court issues a preliminary injunction blocking the new regulations before they take effect on March 1st, we could revert to the old per-country system, and everything I've told you becomes moot. If the regulations take effect, but are then struck down 6 months or a year later after litigation, it's unclear what happens to adjustment applications that were filed under the new system while it was in effect. The most likely scenario, if courts strike down the regulations, is that any I-485 applications filed while the new system was in effect would be allowed to continue processing if the applicant's priority date was current under the new system at the time of filing. But new filings would revert to the old per-country allocations. This would create a window of opportunity. People who filed during the period the new system was in effect would benefit, but people who didn't file quickly enough would be out of luck. This creates even more urgency to file immediately if your priority date becomes current in March. Immigration attorneys are monitoring the litigation closely and will be advising clients on whether to file aggressively under the new system or to wait and see how legal challenges develop. There's no universal right answer. It depends on your risk tolerance, your financial resources, your current status, and your alternatives. But the general consensus among attorneys is that if your priority date becomes current under the new system, you should file. Because even if the policy is eventually struck down, having filed gives you a better position than not having filed. Let me talk about what the next few years are likely to look like if the new system survives legal challenges. Based on the 850,000 pending EB2 and EB3 petitions and the approximately 80,000 visa numbers available annually for these categories combined, immigration analysts project that priority date cutoffs will advance by approximately 3 to 5 months per year in the new worldwide queue. That means if the March 2026 cutoff is December 2014, the March 2027 cutoff might be around May 2015, and the March 2028 cutoff might be around September 2015. These are rough estimates, and actual movement could be faster or slower depending on demand, processing capacity, and how many people decide to pursue alternative strategies or abandon their applications. If you have a priority date in the 2015 to 2017 range, you're looking at 2 to 5 years before you're current. If you have a priority date in the 2018 to 2020 range, you're looking at 5 to 8 years. And if you filed recently with a priority date in the 2021 to 2025 range, you're looking at 8 to 15 years. These timelines are dramatically better than the 50 to 80-year waits under the old system for India. But there's still substantial waits that require patience and planning. Here's the legal disclaimer. This is general information about the employment-based green card policy changes as of mid-January 2026. This is not legal advice, and it's not a substitute for consulting with a qualified immigration attorney about your specific case. The new policy is subject to legal challenges that could result in it being blocked or overturned. Visa Bulletin predictions are estimates that could change based on actual demand and processing capacity, and every individual's circumstances are unique. You need personalized legal guidance to navigate this opportunity and to make the right strategic decisions for your situation. Let me leave you with this. The elimination of per-country caps for EB2 and EB3 represents the single most significant positive change in employment-based immigration policy in decades. If this policy survives legal challenges and remains in effect, hundreds of thousands of highly skilled immigrants who have been trapped in impossible backlogs will finally have realistic paths to permanent residence. Families will be able to plan their futures. Workers will be able to change jobs and start businesses. And the U.S. economy will benefit from retaining talent that might otherwise leave for countries with more rational immigration systems. But this is not the time for complacency or for assuming everything will work out. This is the time for action. If your priority date is approaching the cutoff ranges I've described, prepare now. Get your documents ready. Get your medical exam completed. Make sure your status is secure, and be ready to file the moment you become current. If legal challenges threaten to overturn the policy, having already filed under the new system could protect you, even if the policy is eventually struck down. If this video has helped you understand this massive policy change and what you need to do, hit that like button right now. Subscribe to this channel for ongoing coverage of the Visa Bulletin, the legal challenges, and all developments with employment-based green cards, because this situation will continue evolving rapidly over the coming months. Share this video with anyone stuck in the EB2 or EB3 backlogs, because they need this information immediately to take advantage of this opportunity. Your priority date, your path to permanent residence, and your entire future in America could be transformed by this policy change. Don't let this opportunity slip away through inaction or lack of preparation. Stay informed, stay ready, get professional legal help, and act decisively when your moment comes. This is too important to leave to chance, and you've waited too long to let anything prevent you from finally getting the green card you've earned.